when the tenant's holding over, their rent is very low, and they come into my office and I tell them, I could get you 6 to 8 months without having to pay any rent. So what do? Well, you need a liquidated damages provision. So if they pay rent late, if they're holding over, if they're defaulting in the lease, there should be, you can't have a penalty, but you could have liquidated damages. What no one's doing, but I'm recommending it, and this is kind of new for me too, is I'm into the new memo. I want every court that's ever looked at this has said, let's not look at today. Let's look at what they were thinking. What were they thinking at the time they wrote the lease? What were the forefathers thinking when they wrote the lease? What were the damages that they could possibly entertain then? At the time of the writing of the lease, you have to estimate damages. The courts recognize that it may be impossible to do so. So a lot of times they'll allow this penalty or liquidated damages to go through because we couldn't have a precise number at the time we wrote it. Double the rent for the remainder of the lease. Enforceable or not? It's enforceable. Unenforceable. Court state hearing and actual damages. So do me a favor, in your liquidated damages clause, if somehow this number is not enforceable or we can't collect, then the party shall have a hearing on actual damages. You want to get the highest number possible to penalize them. But you got to do it where it's going to be enforceable in court.